Right now, as you watch this, a parasitic illness called Cyclospora is spreading across 18 states in America. Over 400 confirmed cases, 20 hospitalizations, cases reported in North Carolina, Virginia, Michigan, New York, Texas, Florida, and 12 more states. The most commonly reported symptom, explosive watery diarrhea that can last anywhere from a few days to over a month, symptoms that go away and come back repeatedly. And right now, millions of Americans who bought groceries this summer have no idea whether they were exposed. But here is what nobody is telling you. If you got sick or if you get sick from this outbreak, someone may be legally responsible for your medical bills, your lost wages, your suffering. And there's a clock running on your ability to claim it. Today, 3 rights the food industry, the government, and your insurance company are counting on you never finding out about. First, what you're actually dealing with. Cyclospora chiatensis is a microscopic parasite. When it enters your body through contaminated food or water, it attaches to your intestinal lining and causes cyclosporiasis, an illness characterized by watery diarrhea, cramping, nausea, fatigue, low-grade fever, and vomiting. Without antibiotic treatment, cyclosporiasis can last anywhere from a few days to over a month. Symptoms frequently disappear and then return, making people believe they have recovered when they have not. In 2026, the outbreak season officially began May 1st. North Carolina has confirmed over 60 cases. The average age of those infected is 42, which is exactly your demographic if you're watching this channel. What makes 2026 particularly alarming? Michigan alone reported over 300 cases since June 22nd. New York cases roughly doubled compared to the same period in 2025. This is not a typical seasonal pattern. This is an escalation. And it is happening while the CDC, the agency responsible for investigating the source, is operating with a significantly diminished workforce, following sweeping cuts federally, making the response slower and the source identification harder, which means the contaminated food may still be on shelves. Here is how this parasite got into your food. Cyclospora has historically been linked to fresh produce, specifically basil, cilantro, spinach, and berries. These foods have been connected to past outbreaks. In this current outbreak, only 45 of the confirmed cases involved people who had recently traveled outside the United States. The overwhelming majority got sick from something they ate domestically. Health officials believe the cause is foodborne, but the exact source remains unknown. This is the critical legal point. When a company sells you contaminated food and you get sick, that's not an accident you absorb. That's a liability they owe. The food supply chain involves multiple parties: the grower, the distributor, the packager, the retailer. Under American product liability law, every single link in that chain carries responsibility for the safety of what reaches your plate. If any one of them failed, if proper safety protocols were not followed, if contamination occurred and was not caught, you have legal standing to hold them accountable. Most people never do because nobody tells them they can. Right number 1. Your right to compensation for medical expenses under product liability law. If you consumed contaminated food and became sick from this outbreak, the manufacturer, distributor, or retailer of that food may be liable for your medical bills under strict product liability doctrine. Strict liability means you don't have to prove they were careless. You only have to prove 3 things. 1. The food was contaminated. 2. You consumed it. 3. You became sick as a result. You do not need to prove the company knew the food was contaminated. You do not need to prove they acted recklessly. The contamination itself, if proven, is sufficient to establish liability. Here's what this means practically. Your emergency room visit, your doctor's appointments, your prescription for trimethoprim sulfamethoxazole, the antibiotic used to treat cyclosporiasis, your lost wages from days you couldn't work, your pain and suffering during weeks of recurring symptoms. All of this may be recoverable. But here's the catch, and this is the one the food industry is counting on you not knowing. Every state has a statute of limitations on product liability claims. In most states, 2 to 3 years from the date of injury, but in some states, that clock starts from the date you discovered the link between your illness and the contaminated food, not from the date you got sick. Right now, while the CDC investigation is ongoing, you need to be documenting everything. Save your grocery receipts, save your medical records, write down exactly what you ate in the days before symptoms appeared, every food product, every restaurant, every grocery item you can remember, the severity and duration of each symptom, every medical appointment, and every dollar spent on treatment. This record protects you regardless of which legal path becomes available. Right number 2. Your right to a class action if the source is identified. When the CDC and FDA identified the specific food product responsible for this outbreak, and they will, class action litigation almost certainly follows. It has followed every major food contamination outbreak in American history. The 2018 romaine lettuce E. coli outbreak, class action. The 2015 Chipotle Cyclospora outbreak, class action. The 2020 onion salmonella outbreak, class action. In each of these cases, people who suffered from the contaminated food, even those with relatively mild illness, received compensation through the class settlement. Here's what most people get wrong about class actions. You don't have to be severely ill to participate. You don't have to be hospitalized. If you consumed the contaminated product and experienced symptoms consistent with cyclosporiosis, diarrhea, cramping, nausea, fatigue, you may be eligible to join the class. The key is registration. When a class action is certified, which happens after the source is publicly confirmed, a notice period begins. Class members must typically register within a specific window, often 60 to 90 days. Miss that window and you're excluded from any settlement, regardless of how sick you were. How do you find out when that window opens? 2 ways. First, go to pacer.gov. This is the federal court's public electronic records system. When a class action is filed, it appears here. Search for the food product name once it's publicly identified. Second, your state attorney general's office issues consumer alerts when major food contamination class actions are filed. Sign up for alerts at your state AG's website right now. These are free, they take 3 minutes, and they're the difference between receiving a settlement check and watching others cash theirs. Right number 3. Your right to have your insurance company cover your treatment without a fight. This is the one that generates the most calls to the objection, because when people get sick from a contaminated food outbreak, their health insurance frequently tries to classify the treatment as a pre-existing condition issue or denies the antibiotic prescription as non-formulary. Here's what they're required to cover. Under the Affordable Care Act, all marketplace health insurance plans must cover treatment for infectious diseases, including parasitic infections, as an essential health benefit. There is no valid basis for denial of medically necessary treatment for cyclosporiosis. If your insurer denies your claim for cyclosporiosis treatment, whether that's the diagnostic stool test, the physician visit, or the antibiotic prescription, you have the right to appeal that denial. Use these exact words when you call. I'm requesting a formal appeal of this denial. The treatment denied is for cyclosporiosis, a parasitic infection that constitutes a covered essential health benefit under my plan and under the Affordable Care Act. I'm requesting written confirmation of the denial reason and your internal appeals process within 5 business days. That phrase, essential health benefit under the Affordable Care Act, triggers a specific legal obligation. The insurer must respond in writing. Their reason must be documented. That documentation is your ammunition for both an internal and external appeal. And if your insurer denies your cyclosporiosis treatment, file a complaint simultaneously with your state insurance commissioner and with the Consumer Financial Protection Bureau at consumerfinance.gov. The complaint costs nothing, takes 12 minutes, and insurance companies resolve complaints significantly faster when a state regulator is watching. Here's your action list for today, not tomorrow, today. Step 1. Document your symptoms and timeline right now. Write down or record a voice memo the exact dates your symptoms began, what you ate in the 3 to 5 days before symptoms started, every food product, every restaurant, every grocery item you can remember, the severity and duration of each symptom, every medical appointment, and every dollar spent on treatment. This record protects you regardless of which legal path becomes available. Step 2. If you haven't been tested, get tested. Cyclospora is diagnosed through a stool test. Many physicians do not automatically test for Cyclospora because it requires a specific type of examination called an ova and parasite test. You may need to specifically request this test by name. A confirmed diagnosis through a medical test is the single most powerful piece of evidence in any future product liability claim or insurance dispute. Without a diagnosis, you have symptoms. With a diagnosis, you have a case. Step 3. Save everything. Every grocery receipt from the past 8 weeks, every food delivery order confirmation, every restaurant receipt, every medical bill from your insurer, every prescription bottle, every day of work missed documented in writing. Step 4. Monitor the CDC investigation. Go to cdc.gov and search Cyclosporiasis 2026. Bookmark the investigation page. When the source food is publicly confirmed, check pacer.gov immediately for class action filings. Step 5. If your insurer denies any treatment, appeal immediately using the exact language I gave you in this video. Do not accept the denial. Not on this, not on any treatment for a documented outbreak illness that your insurer is legally required to cover. There's one more thing I need to say about this outbreak because it's directly relevant to your rights. The CDC is investigating this outbreak while operating with a significantly diminished workforce following sweeping federal cuts. The agency's institutional capacity to respond quickly and comprehensively has been substantially reduced. What this means for you practically is this.
The investigation that identifies the source food and therefore the party liable for your illness may take longer than it would have previously. The window between exposure and legal action may compress. The class action filing, when it comes, may move faster than people expect because plaintiffs' attorneys will not wait for a full federal investigation before filing. This is exactly the environment where individual documentation matters most. When the government's ability to protect you is reduced, your own records become your protection. Save everything. Document everything. Know your rights. Because in this environment, the only consumer protection that is guaranteed is the one you create for yourself. Rapid summary. 3 rights the industry counts on you not knowing. Right 1. Product liability. If a contaminated food product made you sick, the manufacturer, distributor, or retailer may owe you your medical costs, lost wages, and more. Document everything now. Right 2. Class action eligibility. When the source food is identified, check pacer.gov immediately. Registration windows are short. You do not have to be hospitalized to participate. Right 3. Insurance coverage. Cyclosporiasis treatment is a covered essential health benefit. If your insurer denies it, appeal using the phrase essential health benefit under the Affordable Care Act and file simultaneously with your state insurance commissioner. Save this video. Someone you know in one of these 18 states needs this information right now. Subscribe to the objection. The food on your table, the water in your pipes, the insurance card in your wallet, none of them protect you automatically. Knowing your rights does. That is why we are here. The objection.